So, good afternoon. It's my privilege and honor to welcome you all and Hersch Lauterpacht Memorial Lectures for this year 2023, given this year by Professor Bhupinder S Chimni on capitalism and the doctrines of international law. The Sir Hersch Lauterpacht Lecture is a series of annual lectures which was founded in 1983 by Sir Hersch Lauterpacht in memory of his father. The lectures are given in Cambridge to commemorate and celebrate Sir Hersch Lauterpacht's unique contributions to the developments of international law. The lectures are given by the world's most distinguished scholars and practitioners in the field of international law. A revised and expanded version of the lectures is usually published in the Lauterpacht Memorial Lecture series from Cambridge University Press. We are grateful to Chimni for accepting our invitation to give this year's series of lectures. Professor Chimni is currently a distinguished professor of law at Jindal Global University, formerly from the Jawaharlal Nehru University. He had his LLB degree from Punjab University, HLML from Bombay University, and PhD from Jawaharlal Nehru University. Professor Chimni is a well-known leader in international. He has taught and visited several distinguished institutions around the world and has served serving on key academic councils and editorial boards. He's also a member of the Institut de Droit International. Professor Chimni has published several books and articles on a number of fields of international law, on third world and international legal order, on politics and globalization, on jurisdiction, on international refugee law, on international commodity agreements, on international institutions. His article, International Institutions Today, an Imperial Global State in the Making, published by EG 2004, is discussed regularly in my global governance classes since then, and is a focus of intensive debate in class. He's one of the leaders, the profound thinkers behind the third world approach to international law or trade. Every piece of his work is a clarion call to rethink international law and international institutions and reflect on the need to transform a system that is based on power to a system that is based on justice. When Professor Chimni started his career, it wasn't clear also to him that people in the global north were aware and were paying attention to his work. Today, the answer is obviously clear. And perhaps this, in and of itself, is a hopeful sign for the future. I promise you that your understanding of international law will gain a new perspective, a new dimension after reading or hearing Professor Chimni and after today's marathon of lectures. And Professor Chimni was generous and courageous enough to present the 3 lectures in one day because of the industrial action that prevents us from meeting again at the rest of the week. And so we are in a special treatment for a week of an afternoon that is, I'm sure, will be memorable. Please join me in welcoming Professor Chimni. Thank
you. Good afternoon, everyone. Thank you, Professor Ben-Belisti, for that very, very warm introduction. It's a great privilege and honor to be delivering the Hersch Lauterpacht Memorial Lectures. Sir Hersch's distinctive, pioneering, and wide-ranging contributions as both scholar and judge has inspired generations of international law scholars across generations, and I am no exception. So it's really an absolute honor and privilege to be here this afternoon. The purpose of my 3 lectures today is to, as the title itself would indicate, to explore the relationship between capitalism and the modern doctrines of international law. I believe that unless this relationship is critically examined and key doctrines reframed in that light, it'll be difficult for international law to contribute to addressing the central problems of our times, be it growing inequalities between and across nations, or the asylum or the climate crisis. Yet mainstream international law scholarship, in my view, does not consider and examine the links between the doctrines of international law and the evolution and development of capitalism. Even critical scholarship has barely explored that relationship, so much so that even imperialism and doctrines associated with it have come to be discussed without reference to capitalism. I'll proceed in the following way. In the first lecture, I will, to begin with, elaborate the reasons for undertaking this exercise and distinguish between strong and weak claims of the linkages between capitalism and the doctrines of international law. Thereafter, I will briefly touch on the difference between internal and external critique of doctrines, the meaning of capitalism, then adopt a formal classification of doctrines of international law. Finally, in an extended discussion, I will review the meaning and epistemology of doctrines and doctrinal research in international law and the historical phases and sources of doctrinal development. I will suggest eventually that the edifice of modern international law rests on shaky foundations. In the second of today's lectures, I'll analyze some systematic, fundamental, functional, and resistance doctrines of international law in detail to illustrate and support the thesis that I'm presenting on the relationship between modern doctrines and capitalism. In the final lecture, I'll argue that the movement has come to reframe the modern doctrines of international law if these are to address the multiple interlocking crises, that is, the fallout of global capitalism, the climate crisis. I will illustrate the idea of recasting doctrines with reference to the overarching doctrine of juscogence and several doctrines of state responsibility with a bearing on climate crisis. I'll conclude with a few reflections on the overall theme of the lectures. Having stated the scheme of the lectures and turning to the my first lecture, allow me to begin by stating in a schematic manner at least 6 reasons why the theme of capitalism and the doctrines of international law needs to be studied. First, in my view, the 2 most critical elements influencing the development of modern doctrines of international law are what I call the logic of territory and the logic of capital. The sovereign state system and capitalism emerged in the same period of history, with each contributing to or constraining the development of the other. But while the logic of territory has occupied the pride of place in the telling of the history of the doctrines of modern international law, that is their evolution and development over time, the relationship between capitalism and doctrines of international law has been largely ignored. There's almost no systematic account of how the logic of capital over time has influenced the development of particular doctrines of international law. Second, the relationship between capitalism and modern doctrines of international law helps foreground and underscore the view that the crucial positivist doctrine of state practice is a reference to the practice of bourgeois states in their different incarnations over time. In other words, the modern doctrines of international law are based on the assumption of the bourgeois state being the normal state. Third, the focus on capitalism helps reveal a significant reason for the underlying unity over time of the modern doctrines of international law, such as the doctrine of sources, jurisdiction, and state responsibility. These doctrines have historically evolved together in response to the same economic, social, and political forces and impulses, and are therefore closely aligned, albeit not in perfect coincidence. Fourth, a focus on the relationship between capitalism and the modern doctrines of international law helps explain the need for exploring the class and race dimensions, veiled by the exclusive reliance on the logic of territory. Without appreciating the connection between these social categories, that is of class and race, and the doctrines of international law, it is difficult to explain the distributive outcomes over time or to progressively reframe them to address the multiple crises in our own times. Fifth, exploring the relationship between capitalism and doctrines of international law helps understand the dynamics of formal and informal change in the international legal order. The contention is that in different phases of capitalism, new doctrines emerge or old doctrines are reworked. Finally, on the epistemic plane, uncovering the relationship between capitalism and modern doctrines helps respond to the question whether doctrines are to be viewed primarily as ideational developments associated with principal figures in the disciplines such as Grotius and Vattel, or a response to material conditions and demands. The epistemic question has an important bearing on how we do history of modern international law, or how we respond to the crisis in our own times. It is important to emphasize at this point that in positing the relationship between capitalism and the modern doctrines of international law, we can distinguish between a strong and a weak claim. A strong claim posits capitalism as the singular explanation for the emergence and development of modern doctrines of international law. On the other hand, a weak claim contends that at best, capitalism is one variable among many that determines the form and content of these doctrines. My own thinking occupies the middle ground. It assigns crucial significance to the development of capitalism in the emergence and evolution of modern doctrines of international law. But this intermediate view recognizes that the actual development of doctrines is a complex and overdetermined process that is mediated by a range of material, cognitive, cultural, and political factors, that is by ideational and historical contingencies. But nevertheless, in due course, relatively stable doctrines emerge in particular eras, reflecting the demands of global capitalism. At this point, I also wish to clarify that insofar as I advance a critique of the modern doctrines of international law based on their association with capitalism, I seek to combine what may be called the internal and external critiques of these doctrines. An internal critique is about uncovering the tensions among elements of a doctrine or between different doctrines of international law. These tensions can result either from different genealogies or the divergent theological and secular sources that inform them, or simply from the logic of territory in the absence of a global state. The internal critique is also about the fact that doctrines are, to use Osprimow's phrase, self-referential. That is, they invent and dictate their own formation and functioning. The internal or discursive critique has been advanced by many scholars, many eminent scholars, such as David Kennedy in The Structure of International Law, Marty Koskanemi in his well-known work From Apology to Utopia, and Osprimow's recent book, International Law as a Belief System. The internal critique of doctrines of international law is powerful, but in my view, limited, as it fails to identify and critique the social basis of modern doctrines. The accent remains on the inside of the law, In contrast, an external critique reveals the material roots and the role of modern doctrines in particular phases of history. In my view, the critique should be centrally about how these doctrines have facilitated capitalism, colonialism, and imperialism. However, in offering my understanding of modern doctrines of international law, I hope to combine both internal and external critiques. And in fact, the ambition would be to transcend this binary of internal and external critiques. I now turn to two other preliminary matters. That is the meaning of capitalism and the possible classification of doctrines of international law. In speaking of capitalism, I deploy a social relations perspective, the sense of which is kept in Marx's view that capital was not a thing, but a social relation between persons. A formal definition of capitalism offered by Marx was that, and I quote, "The capitalist mode of production rests on the fact that the material conditions of production are in the hands of non-workers in the form of property in capital and land, while the masses are only owners of the personal conditions of production, that is, of their labor power." While the history of capitalism is long and complex, going through different phases and assuming different trajectories and varieties within nation states and on the global plane, the propertied classes and their organic intellectuals have inevitably shaped through different ways and forms domestic and international legal doctrines. More specifically, I'm contending that the social relations perspective can be extended to international law, despite the complex mediated processes necessitated by the logic of territory or the existence of a sovereign state system. I would like to add two further brief comments on capitalism. First, while a full-bodied capitalist mode of production with specific social property relations can be said to have emerged in 19th century Europe, there was earlier the phase of what is called mercantile capitalism. While there are different views on the subject, in recent years, the thinker Jairus Banerjee has made out a case for including mercantile capitalism as a type of capitalism. In his view, and I quote, "We need to reinstate a notion of merchant capitalism as a perfectly valid category consistent with Marx's own ideas about capital." Whatever be the validity of this claim, and there are reasons for skepticism even on the basis of the history of doctrines of modern international law, the period of mercantile capitalism is important as it already witnessed, as Gurmeet Bhamra notes, the colonial processes of appropriation, possession, enslavement, and extraction, giving rise to the phenomena of racial capitalism. Even in this early period, we saw, as has been observed by Gonzalez and Mutua, how profit-making and race-making are mutually constituted. It is therefore important in assessing the impact of capitalism on the modern doctrines of international law to take cognizance of the period at least since the 16th century. The material developments in this period, in my view, significantly impacted the shape of modern international law. Second, I wish to stress the internal relationship between capitalism and imperialism, a view that is credited to the German thinker Rosa Luxemburg. The innate tendency of capitalism to expand and universalize explains, in my view, so much of the historical development of the modern doctrines of international law. Finally, before I turn to a discussion of the meaning, epistemology, and historical phases of doctrinal development, a word on the classification of the doctrines of international law that I'm deploying. It may be useful to distinguish between what may be termed systemic, fundamental, functional, and resistance doctrines of international law. Systemic doctrines constitute the foundational doctrines, such as the doctrine of sovereign equality of states, on the basis of which other doctrines are formed and legitimated. On the other hand, fundamental doctrines are, to use the word of Osprimor, organized clusters of modes of legal reasoning used to formulate international legal claims in relation to the rights and duties of actors subjected to international law and the consequences of breaches thereof. Fundamental doctrines include the key doctrines of sources, interpretation, jurisdiction, and responsibility. Functional doctrines are lesser order doctrines in terms of scope and give rise to particular standards of behavior to be observed by state or non-state actors. For example, the doctrine of no harm in international environmental law. Fundamental and functional doctrines can comprise of both primary and secondary rules. Finally, the doctrines of resistance may be viewed as doctrines that seek to reform the systemic, fundamental, and functional doctrines of international law. That's the classification scheme that I am using. It is time to address a more fundamental issue. That is, what is a doctrine? The meaning of a doctrine is relatively more settled in domestic legal systems, wherein it is considered, as Pierre Schlag and Amy Griffin put it, the dominant form of legal currency. There are many and varying definitions of doctrine available. In fact, a variety of definitions. One definition of doctrine is, and I quote, a synthesis of various rules, principles, norms, interpretative guidelines, and values. It explains, makes coherent, or justifies a segment of the law as part of a larger system of law. This definition reveals that even at the domestic level, much cognitive labor has to be expended by courts and scholars in articulating a doctrine. In the circumstances, we need, as Schlag and Griffin observe in their recent book, How to Do Things with Legal Doctrine, a more systematic, what we need is a more systematic understanding of the doctrinal moves. That is the function that they perform. But insofar as international law is concerned, despite its distinctive nature and history, there is little explicit discussion in the literature on the meaning and epistemology of doctrine and doctrinal research. And I found this utterly surprising. There are a series of questions that await to be asked. Allow me to state some of these questions. What are the different ways in which the term doctrine has been used in the literature of international law? Has the meaning of doctrine changed over time? How have national doctrines shaped modern doctrines of international law? What factors account for the alleged stabilization of its meaning around the idea of a systematic statement of the law on any question? Can doctrinal work be separated from theory? And if not, what precisely is the role of theory in the articulation of a doctrine? What kind of social and political theories have informed mainstream doctrinal work? Is there any explicit method for the empirical validation of doctrines in international law? How have accretions to a doctrine in different periods of history been treated? How far are doctrines, in the absence of sufficient rules and decisions of international courts, been shaped by publicists? Why is the sources doctrine finally used to marginalize the place of doctrine in international law, treating writings of eminent publicists and judicial decisions as subsidiary sources? So there are a whole range of questions that are entirely left unaddressed, even as doctrine and doctrinal research are supposed to be the heart of the discipline of modern international law. I cannot address all these questions. Of these, I will touch on three crucial questions: the meaning of doctrine, the relationship of doctrinal approach to theory, and the empirical validation of doctrines. The idea is to underscore the problems in each case. Later, I will discuss the different historical phases of doctrinal development, their sources, and the concerns these raise. Turning to the meaning of doctrine, what needs to be emphasized at first is the multiple ways in which the term doctrine is used in the literature of international law. and pardon me using the numerical method to illustrate this. First, the term has been used to indicate the views of a particular scholar on any topic of international law, such as, for example, Vattel's doctrine of the state or customary law of nations. The term is even deployed to describe his views on international law as a whole, terming it Vattel's doctrine of the law of nations. Other examples of associations of particular doctrines with individual writers include the famous Calvo and Drago doctrines. Second, the term is used for a particular methodology or approach to international law, such as the natural law doctrine or positive doctrine of international law. Third, the term has been used to capture a national approach to international law, such as references to the Spanish or Italian doctrines of international law. Fourth, the term is used to describe what are designated as subsidiary sources of international law, that is, judicial decisions and writings of eminent publicists. Fifth, the term is used to present a particular understanding of what counts as state practice, that is, the doctrine of state practice. Sixth, the term is used to describe the state of the law on a core area of international law, such as the doctrine of state responsibility, which may in turn encompass a string or necklace of doctrines, such as the doctrine of attribution, the doctrine of necessity, the rebus sic stantibus doctrine, and the doctrine of reparation. Seventh, the term doctrine is often used interchangeably with principle. For example, the doctrine and principle of sovereign equality of states. And what is more, the scope depends on other doctrines, such as the doctrine of independence. Eighth, the term is used as a substitute for a particular standpoint on the question or doctrine of international law. Thus, the phrase oppositional doctrine has been used to capture two rival conceptions of a subject. Finally, the term is used for capturing political or quasi-legal posture of states, as in the case of the Monroe Doctrine or the Brezhnev Doctrine. In short, there is no consistency in use of the term doctrine in the literature of international law, especially over time, and like I said, despite its centrality. This creates, in my view, space for confusion, and thereby subjective assessment in determining what is a doctrine and in stating a doctrine, because of the multiple uses of the term doctrine. But arguably, there has emerged a dominant meaning of doctrine and doctrinal research. Let me offer two short statements of what may be considered a stabilized meaning of doctrine. According to Marty Koskanemi, and I quote, doctrine deals with particular substantive aspects of the law, such as, for example, the rules on the use of force, the principles of state responsibility, or the role of sanctions in the enforcement of treaties. Thomas Kuntris, likewise, even as he underscores in his work the multiple ways in which the term doctrine has been used, he uses the term in his work to indicate what he calls technical international law. That is, and I quote, a regulatory approach to a legal question that has become crystallized into a finite set of interrelated and binding norms. So there's a family resemblance between what Koskanemi is saying and Scooter is saying. However, it may be noted vis-a-vis these understandings that some doctrines of international law may be validly classified as doctrines that may not deal with substantive aspects of the law. These doctrines may be foundational, such as the doctrine of state practice. The doctrine of state practice defines what counts as state practice in arriving at rules in a particular area of law. It is in turn informed by a doctrine of statehood, which tells us what is a state. But staying with the stabilized meaning, what is not sufficiently addressed in the literature is the crucial question of the basis or method for arriving at substantive aspects of a law or a legal technical meaning. In what follows, I wish to suggest that positivism or the positivist doctrine, which has dominated the science of international law for 2 centuries, does not adequately grapple with some central questions. That is the process of identifying and weighing of state practice, the role of subsidiary sources in the statement of propositions of a doctrine, the relations between doctrine and theory, and the protocols of the empirical validations of doctrines, leaving its formulation suspect. So as I claimed before, I'm skeptical about the claims of mainstream international law scholarship. We know that fundamental to positivism is the social fact thesis, which claims that legality is ultimately a matter of fact, not value. In the words of Yale professor of jurisprudence, Jules Coleman, the social fact thesis is the core claim of legal positivism. It cuts across all positivist positions. I do not wish today to engage here with complicated debates over the tenets of international legal positivism or explore the meaning, scope, variance, and sufficiency of the social fact thesis. My concern here is basic and limited to the traditional emphasis of international legal positivism on state practice to validate as customary international law particular doctrines of international law, including the doctrines of sources and the doctrine of state responsibility. But since state practice does not identify or speak for itself, the writings of publicists and decisions of international tribunals play an important part in arriving at the statement of substantive aspects of the law. This is more readily admitted when the more inclusive domestic understanding of doctrine is adopted on the international plane, which speaks of a synthesis of a diverse set of materials, including values, to arrive at the substantive aspects of law and any question. So there's the broad view of doctrine and there's the narrow view of doctrine. Anna Peters points out that, and I quote, because of specific qualities of international law, doctrinal analysis in the field is of limited value. So she departs from the mainstream view of the centrality of doctrines. In her view, and I quote, the stuff of international law is less dense than in the main field of application for doctrinal research, such as domestic contracts, tort, and property law. This situation is, as she points out, often accompanied by the absence of codified rules or sufficient judicial decisions. My question is, if that is correct, if that assessment is correct, the question is, what are the other materials used to fill the gaps in the course of doctrinal research, leading to the statement of propositions that constitute a doctrine in the domain of international law? In many instances, in my view, legal concepts and practices of advanced capitalist nations and bourgeois ideology provide the resources with which these gaps may be filled. Because as she says, there's not enough material in international law to build doctrines. The only other alternative set resources are national doctrines and bourgeois ideology. Be that as it may, the question is whether such an approach is in strict conformity with the tenets of international legal positivism. But returning to the traditional or practitioner's understanding of doctrine, which allegedly relies primarily on state practice to state substantive aspects of the law, I wish to make three elementary points. The first is that the meaning and scope of the term state practice is not always clear. For example, in the case of a norm of customary international law, the International Law Commission, in its draft conclusion on the subject in 2018, differentiate between what it calls forms of state practice and what it calls forms of evidence of acceptance law. These are two different kinds of state practices distinguished within. And the latter to ascertain the element of opinio juris. But since the latter is also state practice, it is not clear what happens when there is a preponderance of evidence of opinio juris and limited available of regular state practice. That is what is not clear is the dynamics between what we can call regular state practice and that state practice which is ascertained in order to substantiate the second element of opinio juris. The second point relates to the process through which state practice is identified, collated, organized, and interpreted. The question is whether the positivist pretense of a neutral and scientific exercise is sustainable. As Papo and Weiler observe, scientific doctrine is an oxymoron. The reality is that state practice cannot be identified and assessed outside the frame of particular values and preferences. As Koskanami explained, and I quote, "It is not obvious where the line between theory and doctrine lies. If it is usually assumed that doctrine proceeds by interpreting and systematizing the normative materials, how that work is carried out depends on theoretical views about the purpose of the interpretation and the types of materials to be included in the system." To put it differently, even if it is correct to claim that there is something called law's own truth, the constituted nature of social and historical context and dominant ideologies cannot be denied. As Jack Balkin observed, shared ideology does not merely produce the content of legal doctrine. It makes the content of legal doctrine intelligible to us and binding upon us. This fact is mostly ignored. And that ideology, I'm arguing, is bourgeois ideology. The third point, and again a very crucial point, with the practice of international legal positivism, is the absence of established protocols of empirical validation. This is almost entirely undebated. In an important article on the subject, Lee Epstein and Gary King write that in undertaking doctrinal research, and I quote, "Too much legal scholarship ignores the rules of inference and applies instead the rules of persuasion and advocacy. There is a tendency to collate data that support particular value goals with roots in dominant ideologies." There are several issues here from the perspective of international law. Firstly, choices have to be made in assigning weight and significance to particular state practices. Second, there is matter of what may be called the geography of state practice. Very often the assembled state practice is in and of particular geographical spaces, which are then made to stand in for unavailable state practice in other geographical spaces. Thirdly, mainstream doctrinal research tends to neglect, as Epstein and King observe, a basic premise of all empirical research, and indeed of every serious theory of inference, that all conclusions are uncertain to a degree. But in contrast, often firm conclusions are drawn from sparse evidence. Finally, it is rare that an alternative hypothesis or explanation with a better fit with data or social facts is considered. In other words, in view of the lack of clarity of the meaning of state practice, deficiency in the availability of state practice in many areas, the role of ideology in weighing state practice, and the absence of protocols of empirical validation in articulating particular doctrines, it is odd that Article 38 of the Statute of ICJ assigns the writings of eminent publicists a subordinate status. What is more, as Ian Scobie observes, and I quote, "Such a depreciation is paradoxical, if not contradictory. The sequence of Article 38 itself is a doctrinal choice, the choice of legal positivism with a legalist tendencies." In reality, as he writes, in international law, doctrine is neither auxiliary nor ancillary, but principle at its very foundation, even today, and in spite of its own self-image. He's using the term doctrine to capture the subsidiary sources of international law. The overall idea of Article 38 appears to be, in my view, to sustain the impression that the role of publicists is marginal in the framing and articulation of doctrines of international law. The rendering of writings of eminent publicists as a subsidiary source helps obscure the role of bourgeois ideology and organic intellectuals of capitalism in the making of international law, especially in the fact of any exploration of the relationship between doctrine theory or the protocols of empirical validation. To sum up, a technical legal statement of a doctrine conceals the contestable epistemological and ontological assumptions used to identify, collate, interpret, and validate particular propositions of law. The idea that a statement of doctrine that all reasonable persons would affirm comes into question the moment you contest its claim to descriptive objectivity. In fact, there's little doubt, as one researcher observes, positivism constantly makes normative substantial choices. The most constant of those choices results in economic interests, privileging economic interests over justice or other political or ethical considerations. Unsurprisingly, the positivist doctrine only pretends to be concerned with what is true. It has, of course, as we all know, never been concerned with what is just. I now turn to the historical phases of doctrinal development to elaborate what is true is influenced and shaped by material developments related to the evolution and development of capitalism and the telos and state of international law in each era. Depending upon the times and state of international law, a doctrine can be articulated by an individual writer or by a designated institution based on a diverse set of sources ranging from the theological to the secular. Broadly speaking, the development of doctrines of international law since the 16th century may be classified, in my view, into 5 phases. First phase is the long phase from 1500 to 1760, which I describe as the era of natural law doctrines. The next phase is from 1760 to 1875, which is the period of transition to positivism. The third phase is from 1875 to 1945, which is the era of positivist doctrines. The period from 1945 to 1985, I call the era of Cold War doctrines. And then from 1985 to the present, the era of neoliberal doctrines. These are my classification of the history of the development of doctrines. And my argument is that each of these phases is related to developments in capitalism. And I will try and argue this. In examining each phase of modern international law, a number of questions can be asked. What is the contribution of publicists in the formulation and statement of doctrines? What is the range and type of source material used in giving form and substance to doctrines? What is the extent to which private law analogies contribute to the framing of particular doctrines? What is the notion and extent of state practice that informs the doctrine of international law in each other? In the general remarks to follow in each phase, I merely wish to say enough to distinguish different phases in relation to material developments and gesture towards sources used in this period. The exercise is important because the excavation of any contemporary doctrine of international law can disclose layers of sedimentation introduced by time, each layer reflecting a mix of ideology and state practice. A genealogy of doctrines helps, among other things, caution against the unreflected and seamless incorporation of past iterations through often relying on the work of one or two publicists to sustain or legitimize particular understandings of contemporary doctrines. Such an approach only compounds the problem of the absence of objectivity and neutrality. I first turn to the first long phase between 1500 and 1760. The first phase of the development of doctrines in modern era is more than the 2 centuries between 1500 and 1760, in which natural law doctrines prevailed, and which saw the simultaneous emergence of mercantile capitalism, colonialism, and the sovereign state system in Europe. In this period, the significance of writers in producing doctrines cannot be overstated. It was out in the open. As one researcher observes, the construction of a system of the law of nations was at that time mainly a doctrinal and constructive enterprise. Please do not miss out the meaning of the term doctrinal being used here, directly a reference to writing of publicists. A well-known example is the doctrine of freedom of the seas, which was propounded by Grotius. Insofar as its links with material developments is concerned, one author aptly classifies the Jurisprudence as a revolutionary capitalist text. He writes, and I quote, "The text taxonomic reclassification of the high seas as legally free directly facilitates the unlimited expansion of free trade, the summum bonum of the embryonic capitalist world economy." As to the sources used in this period, these were the available ideational material. As Koskinen points out in his book, To the Uttermost Parts of the World, the thinkers of the time created structures of legal argument using a combination of materials lying around in order to persuade those whose opinion and words mattered. These sources were varied, including Roman law, natural law, canon law. But as Schwarzenberger wrote in a well-known essay in the Harvard Law Review, also included quotations from the Bible, church fathers, classical writers, mythology, history, and state practice. From the perspective of the evolution of bourgeois international law, mention may in particular be made of Roman law. Arthur Nussbaum writes that in the early development of the doctrine of international law, it was an indispensable tool. Likewise, Lauterpacht wrote that, and I quote, "A critical examination of the classical writers shows that although they rejected formally the analogy to private law, they took over its rules and conceptions under the form of law of nature in the case of Grotius, or of the reason of thing in the case of Banker Scheuer." More specifically, Lauterpacht pointed out that the chief legal arguments in the development of the conception of the freedom of the sea and of the territorial waters were drawn from private rules of possession and property. In short, as in the instance of bourgeois law, Roman law concepts and categories played an important role in the early articulation of the doctrines of international law. In the second phase, from 1760 to 1875, writers continued to be the most influential source of doctrinal developments. In the beginning of this period, Vattel produced his influential work, The Law of Nations, or the Principles of Natural Law Applied to the Conduct and to the Affairs of Nations and of Sovereigns. The interlinked doctrines that he advanced of state, self-preservation, non-intervention, commerce, promises, perfect right, and the use of force was in keeping with the era of increasingly competitive mercantile capitalism and imperialism. It is no surprise when Tony Young, for instance, writes that, and I quote, that Vattel's particular vision of imperialism is best understood in terms of his vision of commerce. It is, as he goes on to observe, a vision that encompasses not only trade, production, and other such economic activities, but foundational ideas of property and possession. Vattel's vision of international law and the international system may be understood as presenting commerce as an alternative to force and conquest. What I'm trying to do is I'm trying to show how most of the doctrinal developments were because of developments within capitalism itself. By this time, the sources used to articulate doctrines of international law changed. The influence of Roman law had begun to wane, as the major writers of this period, Wolff and Vattel, were, we are told, not very familiar with it. Insofar as canon law was concerned, one researcher writes that by the 17th century, canonical sources were increasingly abandoned, and it became rare to find an author who relied on such sources. While the presence of natural law persisted, the emphasis was already shifting to state practice. But in much of this period, state practice was yet to be used to articulate a distinct doctrine of customary international law of the kind that we have today, even as customary practices were taken into account in the statement of doctrines. According to Gourier, and I quote, "None of the authors clearly expressed that customary law could be a source of international law, even in their analysis of the law of war. The reason being that both the logic of territory and the logic of capital, that is the sovereign system at capitalism, had to mature before customary international law could become a primary source of international law. That is, the basic categories themselves could not fully be formed in the absence of certain material development. In third phase, between 1875 and 1945, methodological positivism and the accompanying doctrine of state practice assumed precedence. As Anthony Carty notes, it is in this period that the notion of state practice was invented by international legal doctrine by positivists. The era of what was called the highest state of capitalism dictated the peculiar features of the doctrine of state practice. That is, the doctrine of state practice itself is now undergoing transformation to meet the needs of capitalism. I may mention 3 of these features of the doctrine of state practice in this period. All evident, but need to be spelled out. First, the notion of state practice was given a Eurocentric interpretation. As Alexandrovich has observed, while positivism claimed to be empirical, it strangely left out state practice of and with non-European nations. So state practice, the doctrine of state practice circumscribed the very notion of state practice by leaving out the practice of non-Western nations. Or as Carty puts it, it is positivist doctrine which defines what constitutes legally significant state practice. What was presented as scientific evidence is of a handful of European states in their relations with each other. Second, the doctrine of state practice firmly naturalized a bourgeois theory of state. Or as Evgeny Pashukan observes, the state only becomes the subject of international law as the bourgeois state. It also meant, given the internal relationship between capitalism and imperialism, that the imperial state became the legally relevant state in collecting state practice. That is, the practice of imperialist states define what is state practice and what is what kind of state practice matters in the making of international law. Third, the positivist doctrine insulated the doctrine of state practice from moral or ethical critique. In this period, doctrinal positivism justified the colonial project to inter alia the doctrine of protectorates, unequal treaties, discovery, occupation, conquest and cession, terra nullius, capitulation, quasi-sovereignty, just war, etc., without deeming it necessary to subject them to any moral or ethical interrogation. It is interesting that in this period, private law knowledges were no longer a source of doctrines. Yet in this period, the role of publicists came to be diminished by courts. And I want to emphasize this. On one hand, through these centuries, the publicists played a central role in defining the doctrines of international law, in spelling out the doctrine of state practice, in weighing state practice. But by the end of this period, already that role was being circumscribed, which then found its way in self-defining this source as subsidiary source. The role of the publicists came to be diminished by courts, at first by stating, as for instance, Justice Bray did in delivering the opinion of the Supreme Court of the United States in the Pacata Habana case of 1899, that writers are relied upon only for trustworthy evidence of what the really is, about what the law really is. The Privy Council was more direct when it observed in 1920 that reliance must be paid less on writings of distinguished scholars more on decided cases. Thus, the influence of writers began to be obscured in the name of positivism, pragmatism, and a constrained vision of the function of international law. It essentially allowed the role of bourgeois ideology to be obscured. But as has been observed earlier, given the flawed positivist methods, it did not reflect the reality. The last two phases. The fourth phase is between 1945 and 1985, that is doctrinal scholarship in the post-colonial era. Turning to this period, the era of decolonization, the meaning of doctrine began to be confined to a statement. It is in this period that the meaning of doctrine began to be confined to a statement of the prevailing law, sans acknowledgement of particular genealogies and sources that shaped them. We see the seamless narration of doctrines. Grotius and Vattel are cited along with contemporary scholars in state practice, as if each is speaking to the same set of issues with the same set of sources. This development came about in the face of contestation of existing doctrines by post-colonial states. There's a clear shift in how the idea of state practice is now being debated in the post-colonial era. In order to protect the interests of advanced capitalist states, it was important to eliminate the space for plural understanding of doctrines. Koskenny is thus correct in pointing out, and I quote, "It often appears that international law has since the mid-20th century turned increasingly from theory to doctrine. Large teleological questions have been set aside in order to work on technical rules and practices. Yet that work too is informed by larger visions, although they may lack academic articulation." That is the distancing of theory from doctrine happens in the post-colonial period in the face of constant questioning by post-colonial states. The standard textbooks of international law played an extremely crucial role in disseminating theoryless doctrine. Prior to this, theory was much more visible. The textbooks sometimes presented dubious doctrines as if these were written in stone. In the last phase, and this is a very critical phase because it brings us to the present times. In the last phase, beginning circa 1985, with the end of the Cold War and diminished challenge from post-colonial nations, there were two developments. The consolidation of the technical legal meaning of doctrines, accompanied by the codification of key doctrines, such as the doctrine of state responsibility and customary international law. That codification exercise begins post-1985. Both are in tune, in my view, with the phase of neoliberal capitalism. In 2001, after decades of effort, the articles on state responsibility came to be adopted, a subject that I'll address in my next lecture. In 2011, the subject of formation and evidence of customary international law was proposed by the reconstituted working group of the ILC on the long-term program of work. There is no record of the discussion in the working group of the ILC as to the reasons for proposing the subject of customary international law. And therefore, these are not known, but these can be gleaned from a statement of Michael Wood. Among the reasons he cited were, and I quote, "The ideological objections to the role of customary international law have diminished, and the concern with controversial attempts of domestic courts to grapple with this issue." In short, the post-Cold War era, amidst the expansion of neoliberal capitalism, was seen as a favorable period to consolidate the advanced capitalist states' understanding of customary international law. It is also no accident in the same year, that is 2011, in which the codification of rules relating to the emergence of customary international law was proposed, the following topic was also recommended by the ILC working group: the fair and equitable treatment standard in international investment law. At least one reason given was that the meaning and scope of fair and equitable treatment remains controversial. It is also interesting that subsequently the special rapporteur on the subject raised the issue whether the fair and equitable standard is now part of customary international law and whether the standard is synonymous with the international minimum standard, largely from the practice of states. So all these subjects are now being codified and each interfacing with the other. In this respect, he observed, the special rapporteur, how important the study and conclusions on customary international law were to this study offering tools of analysis. In short, the post-Cold War era, which saw the expansion of neoliberal global capitalism, was seen as an opportune moment to consolidate suitable understanding of key doctrines, such as the doctrines of state responsibility and customary international law. It is also in this period that the severing of doctrine from theory was completed. It has made any resistance from post-colonial nations to the extant doctrines of international law difficult. I'll end with some concluding reflections. The study of the entangled relationship between social forces, modes of production, ideologies, and doctrines of international law has been relatively neglected in the literature of international law. While the turn to history in recent years has seen different histories produced and complicated debates about historical methods, these only rarely engage with the condition of capitalism in different eras and the corresponding impact on the doctrines of international law. To be sure, this does not mean doing some form of naive reductionist history, which ignores the complex factors that have shaped modern doctrines of international law. It has also to be recognized that different legal systems with varying doctrines can support the capitalist project. But to do the history of international law without taking on board its intimate relationship with capitalism is deeply problematic. Among other things, the relationship helps understand the dominant positivist method is as much moved by state practice as by bourgeois ideology and interests. The pretense of empirical validation is often difficult to sustain. The distinction between doctrine and theory that it assumes is also unsustainable. In the next lecture, I hope to look at, in a little more detail, the relationship between capitalism and some systemic, fundamental, functional, and resistance doctrines of international law. I'll simply conclude by saying the argument that I'm making is about the flawed epistemological and ontological assumptions of mainstream positivist doctrine, leading to the suspicion that many of the doctrines of international law, which seem to be written in stone, are extremely suspect, because there are no sort of substantive reasons to sustain them, and in some measure they are the work of bourgeois ideology. Thank you.